Hi, my name's Miriam Van Hukelum, and I'm an attorney with the Allers and Cooney Law Firm in Des Moines. I'll be presenting today about legal requirements in Iowa for the use of physical restraint, seclusion, and room clears, all of which have new requirements that are effective during this current school year. Just a disclaimer first, this presentation is intended only for informational and educational purposes and to provide general information about the topics that we're covering today. Individual situations and how the law regards them are very case and fact specific. And so if you have any questions or need for legal advice or guidance, please contact your agency's legal counsel. Or if you are not authorized to contact your agency's legal counsel, please talk to an appropriate administrator in your agency to determine next steps. Today's training will cover the requirements in Chapter 103 of the Rules of the Iowa Department of Education governing corporal punishment, physical restraint, and seclusion. New rules on these topics go into effect on January 20th, 2021. I will also briefly cover information from Senate File 2360, which was passed into law in the summer of 2020 and is currently effective, and it involves new guidance around the use of room clears. To start with some basics, under Chapter 103, corporal punishment is and has for a long time been banned in the state of Iowa. Corporal punishment includes any intentional physical punishment of a student that is intended to harm the student or to cause them pain. Some non-examples of conduct by an employee that would not constitute corporal punishment include any verbal recrimination or chastisement. So you're not putting hands on a student, you're just saying something to them. Don't do that or stop doing that. Reasonable requirements for PE or sports, and I would note that it says reasonable. Actions that are consistent with a student's IEP, behavior intervention plan, individualized health plan, or safety plan that do not involve the use of restraint and seclusion or corporal punishment and therefore don't implicate Chapter 103. Reasonable periods of detention like after school detention, before school detention, lunch detention, in-school suspension, things like that. Actions by an employee toward a non-student, or the use of reasonable and necessary physical force. So Chapter 103 does allow school employees to use reasonable and necessary force under certain limited circumstances. And this includes, but is not limited to, the use of restraint or seclusion. However, the bar for using physical restraint or seclusion is much higher under the new Chapter 103 rules. And any use of physical restraint or seclusion will involve requirements of additional documentation, debriefing meetings, and other things that we'll cover later in this presentation. As a general rule, when is the use of force reasonable and necessary? This is going to be a fact-specific question that will require you as a school employee to use your best judgment in determining whether your actions, if you use physical intervention of any kind with a student, would be reasonable and whether it would be necessary. So the circumstances under which Chapter 103 allows the use of physical force of any kind are to quell or prevent or stop a disturbance or prevent an act that threatens physical harm to any person. So that is the student, any other student, any employee, or anybody else present at the time. You're also allowed to use physical force to obtain a weapon or other dangerous object, to defend yourself or defend others, to remove a disruptive student from class, from school grounds, or from school activity, to prevent a student from inflicting harm on themselves, or generally to protect the safety of others. And how much force you use is going to be a question of how significant the behavior that falls into one of these categories is. Force is a sliding scale that can be anything between putting your hands up to stop a student from crashing into you, to much more significant uses of physical force to restrain a student to prevent them from engaging in self-harm or harm to others. In determining the reasonableness of the use of physical force, you have to look at the size, physical, mental, and psychological condition of the student, The use of physical force and how much force is necessary may be very different with a kindergartner from a 6 foot two, 200-pound 10th grader. The nature of the student's behavior or misconduct. The more severe the behavior, the more likely it is that the use of physical force or physical intervention is reasonable. The less severe or significant, the less likely it is that some sort of physical intervention is reasonable. Somebody who is being disrespectful or who breaks a pencil or tears up a worksheet, as compared to a student who is flipping over a desk or throwing heavy objects at others in the classroom. Those are different behaviors, and the non-physically threatening or physically harmful behaviors are generally not going to warrant the use of physical intervention to the same extent that a more dangerous, more harmful behavior would. The instrumentality, if any, used in applying force. An example I often use here is if you move a desk between yourself and the student, you use the desk to block the student. Is that reasonable under the circumstances based on the threat that the student posed? It may be in some cases, and it may not be in others. The extent, if any, of any or nature of any resulting injury to the student from the use of physical force, including mental and psychological injury, but also, of course, including physical injury as well. Now, the fact that a student has been injured in the use of restraint or seclusion or other kinds of physical intervention does not necessarily mean that the use of physical force under those circumstances was unreasonable. For example, if a student has a knife, it may be reasonable to take physical action to get that knife away from the student, even if it results in the student having some bruising or some scrapes. Of course, we don't want students to ever be injured, but there are times where that injury is a necessary byproduct of preventing a very serious threat to the student or to the employee or to others present. So, in determining reasonableness, we look to whether there's any injury to the student. And again, at the other factors involved here, the nature of the student's behavior and misconduct, the size, mental condition, and so forth, in determining whether under those circumstances the injury, if any, suffered by the student was reasonable, or whether it's evidence of an unreasonable excessive use of force. And then the motivation of the school employee in using physical force. When a school employee uses force to protect him or herself, to protect others, to protect the student who's involved in the incident from harming his or herself, that is much more reasonable motivation than if the employee gets frustrated or is angry because the student was disrespectful. Those are typically going to be, not ever going to be a justification for using physical force with a student. So the motivation of the school employee is something important in looking at whether the school employee's actions were reasonable under the circumstances. Now, as I mentioned a few minutes ago, there's a higher bar under Chapter 103 for when the use of physical restraint or seclusion is reasonable and necessary. There are only three circumstances where school employees are allowed to use physical restraint and seclusion. First, to prevent or terminate an imminent threat of bodily injury to the student or any other person. An imminent threat means something that is about to happen. It has to be something that is happening soon or happening now, not something that may happen eventually. And we'll talk a little bit about the requirement to use other less restrictive means of addressing student behavior prior to restraint or seclusion, if possible, under the circumstances. So the imminent threat means you're stepping in and using physical restraint or seclusion, or else bodily injury is going to occur in the very near future, immediately, if you don't intervene. You can use it also to prevent serious damage to property of significant monetary value or significant non-monetary value. So, tearing up a worksheet or a workbook, breaking a pencil, things that are not of significant value are not going to justify the use of physical restraint or seclusion to prevent property damage. So not all property is valued the same way in the use of physical restraint or seclusion. It has to be significant value. Or you can use physical restraint or seclusion where the student's actions seriously disrupt the learning environment or when necessary to ensure the safety of the student or any other person. So those are your three permissible grounds for using physical restraint or seclusion. It's not allowed for any other reason. So if a student is disrespectful, if a student's not getting in line when they're supposed to be, or if a student is damaging property of low value, those are not ever going to be permissible bases for using physical restraint or seclusion. You also have to show that less restrictive alternatives to physical restraint or seclusion would not have been effective under the circumstances, would not be feasible, maybe because the threat was so imminent and so immediate or so severe that you couldn't stop to use other less restrictive means. For example, if a student is wielding a weapon, you don't necessarily ask them if they want to take a break or use a sensory item to de-escalate, right? You're going to step in to try to prevent the student from harming themselves or others, not offer other alternatives or use other less restrictive means. Or where you've used less restrictive alternatives but they've failed, you've attempted to give the student options to take a break or to use a preferred item if that is consistent with their behavior plan, and it hasn't worked. And now the student's behavior is either a serious disruption or an imminent threat of injury, or somehow poses risk to the safety of the student or others. And in order for restraint and seclusion to be reasonable, you have to show that it complies with all of the rules of Chapter 103, which we'll be going throughout this presentation. Physical restraint is defined in Chapter 103 as any personal restriction that immobilizes or reduces the ability of the child to move the child's arms, legs, body, or head freely. So, holding a child's hand, if they're able to move their arms, just holding a child's hand to guide them down the hall would not constitute a physical restraint. But wrapping your arms around a child to keep them from throwing punches, if it restrains their arms, would constitute a physical restraint. Some non-examples of physical restraint. These things do not meet the definition. Any technique that is used by a trained staff member or student for the specific purpose for which it was designed. And this will come into play if a student has particular techniques in their IEP or behavior plan that are intended to support the student's disability-related needs. But if you're using those techniques, like deep pressure, for example, maybe something that some of you are familiar with, big deep pressure hug, that has to be something that you personally have received training in order to use it consistent with a student's BIP or IEP. Instructional strategies, such as physically guiding a student during an educational task. That might be putting your hand over their hand to help them form a letter or to help them move, a paintbrush over a page. That might be helping position, their hands or feet in some sort of a PE or sports context. Handshaking and hugging are not considered to be physical restraint, even though a hug does briefly restrain a student's arms, as long as it is, not disciplinary, not intended to be punitive, and is just a, hey, how are you hug. And non-disciplinary physical contact generally. So, putting a hand on a student's back, kind of guide them where they need to go, but you're not moving them, you're not restraining them. Seclusion is defined in Chapter 103 as any involuntary confinement of a child in a seclusion room or area from which the child is prevented or prohibited from leaving. Now, those of you who had some familiarity with Chapter 103 before, this definition of seclusion has changed, so it may have some words in it that you're not familiar with, and it may be a little bit different than you remember. So first, I would point out involuntary confinement. This means you're putting a student in a seclusion room or other area against their will. That is different from a student who may have the use of a calm down area in their IEP or health plan or safety plan or BIP, and where the student voluntarily goes into that calm down area to de escalate, and where we are not preventing them from leaving or telling them that they're not allowed to leave. Those are two different things. So, involuntary confinement in a seclusion room or area where the child is prevented from leaving or prohibited from leaving. And so, prohibited from leaving may be that you tell them you're not allowed to leave until I say you can. Or if you leave before I tell you you can, you will have X consequence. That's prohibiting a student from leaving. However, preventing a student from leaving a classroom or a school building does not constitute seclusion. So if you use a room clear and you prevent a student from leaving the classroom, you've done a room clear and the student is in the classroom and you're standing in the doorway and you're blocking the student from leaving the classroom, that's not considered seclusion under Chapter 103. You would not need to follow the all of the documentation and other requirements that we're about to cover. Although, as a lawyer, I always advise documentation of any significant incident, and room clears now have their own documentation requirements to make it more confusing, right? But in this case, it wouldn't be considered a seclusion, and so you wouldn't document it as a seclusion. Also, keeping a student from eloping from a school building is not considered a seclusion. So if they're heading for the front door and you stand in front of the front door, or somehow otherwise prevent them from leaving, not a seclusion. In a seclusion room means any room, area, or enclosure, whether in or out of a classroom, that's used for seclusion. A non-example of a seclusion would be where a school employee is present within the room with the student and is providing services to the student, such as crisis intervention, or instruction. So if you're in a small room with a student, or a seclusion room with a student, and you are coaching them, or talking with them, or otherwise doing whatever the student needs to help them de-escalate, you're in there with them, that's not considered a seclusion. Or in circumstances where a small room that may be used for seclusion is also being used for instruction, and the school employee is present with a student in the room, does not constitute a seclusion. And those are just some kind of more unusual circumstances that sometimes pop up from time to time, but where the department in revising Chapter 103 said these do not constitute seclusion. Now defining room clears. A teacher is only allowed to clear all other students out of a classroom. So that's the definition of room clear, where the teacher clears all other students out of a classroom where it is necessary to prevent or terminate an imminent threat of bodily injury to a student or other person in the classroom. So it's important to note here that room clears are only available as an intervention in a very limited circumstance, less so restraint and seclusion, where you can use restraint or seclusion to deal with a serious disruption or major property damage. You cannot use room clears for those purposes anymore. Room clears now can only be used to prevent or terminate an imminent threat of bodily injury. And again, imminent means it's about to happen or it's happening right now. If it is anything other than an imminent threat of bodily injury, use of a room clear is no longer permissible. And again, that's a change in the law that went into effect during the summer of 2020. Student IEPs and behavior plans cannot require the use of room clears or clearing out all other students from the regular classroom in order to calm the child whose IEP or BIP it is. So these are, again, new requirements limiting the use of room clears from what some of you may have been, familiar with from previous school years. Now, bodily injury is a term that's used both in Chapter 103 in defining restraint and seclusion and in the room clear law. And so bodily injury means any physical pain, illness, or any impairment of physical condition. Some of you may be familiar with the term serious bodily injury, which is used in other capacities in laws like the IDEA. This is not serious bodily injury. That's a pretty high threshold. That is, a more significant level of harm. So this is any bodily injury that causes any physical pain, illness, or impairment in any way. Physical restraint and seclusion are prohibited under certain grounds. You can never use them for these reasons. First, as punishment or discipline. A student was disrespectful or non-compliant, and so we're going to put them in a seclusion room to punish them for that. Never okay, never reasonable, never necessary. To force compliance or retaliate, you have to go in the seclusion room until you will follow my directions. Again, never reasonable, never necessary, cannot form the basis for use of physical restraint or seclusion. You cannot use it as a substitute for appropriate educational or behavioral support. So when using physical restraint or seclusion with students, it should be a last resort. And there should be, especially for students who are more frequently involved in pretty escalated behaviors, there should be a team in place, IEP team, 504 team, some kind of a team if the student hasn't been staffed yet, who is looking at what supports the student needs to be successful and to reduce the incidence of these behaviors. So we shouldn't just be responding to the behaviors. There needs to be some sort of a plan or preventative strategy in place to determine how to meet the student's needs. And that may involve evaluating them and determining whether they're eligible for services under Section 504 or the IDEA. It's never allowed to use restraint or seclusion to prevent property damage unless it is significant property damage to property or serious damage to property of significant value. So that's the only exception. Minor damage to property or damage to property of low value is never going to justify the use of restraint or seclusion. It cannot be used as a routine school safety measure or as a convenience to school staff. Who is allowed to use restraint and seclusion? Only trained school employees. And if a trained employee is not available immediately due to the unforeseeable nature or of the consequence, another employee may impose restraint or seclusion that is otherwise permissible under these rules. So where there's not a trained employee because we had no reason to know that this incident might happen or that a student might require this, another employee can use physical restraint or seclusion as long as it's compliant with these rules. And this is why this training is being pushed out to as many school employees as possible, because you never know when you may be in the position that you have to step in and intervene to protect yourself, to protect another student. And you want to make sure that your actions are compliant with the law to make sure that you're doing the right thing, and certainly to make sure that you're not doing something that could be harmful to a student. How long can restraint or seclusion last? Generally, it should never last any longer than necessary based on research and evidence to allow the student to regain control of the behavior that led to the threat or other need for use of restraint or seclusion, or if there's a medical condition that puts the student at risk of harm. So if for some reason, if you have a student who has epilepsy or asthma or something where the continued use of restraint or seclusion may put the student at risk of harm, you need to stop the restraint or seclusion and figure out what happens next. And if the student's behavior has resolved to the point that that threat or behavior has ended, they cannot be continued to be restrained or secluded beyond that point where the behavior or the threat has ended. So there may need to be some look at, your training or your agency's training around when do we know for this student or in general that the need for restraint or seclusion is ended, because it has to be ended at that point and not any later. What if more time is needed? So first we look to the student's IEP, behavior plan, individualized health plan or safety plan, if they have one. Or we look at the cutoff in the rules, which is 15 minutes. So generally, the maximum amount of time for a restraint or seclusion is going to be 15 minutes, or the student is going to be entitled to be provided with breaks for personal and bodily needs unless it would endanger the child or others to provide those breaks. So that's after 15 minutes, and this is shorter than the previous Chapter 103 rules. So this is going to be an adjustment for those of you who are familiar with the timeframes in those rules. And if you exceed 15 minutes of restraint or seclusion, the employees involved in the restraint or seclusion has to get approval from an administrator or an administrator's designee at the 15-minute mark, and then every 30 minutes after that. So 15 minutes and then 45 minutes total, and so forth every 30 minutes thereafter, if necessary. There are also obligations to notify the parents, and these have changed as well. You are required to notify the parent of the situation as soon as practicable after the situation is under control, but in no circumstances can that notice be any later than within 1 hour of the end of the school, 1 hour of the restraint or seclusion, or the end of the school day, whichever comes first. So, for example, if you have a student that you have to put in a seclusionary timeout at 11 o'clock in the morning, and the school day ends at 3:20, you will need to notify the parents as soon as possible, so the sooner the better, but no later than noon that day, in order to comply with these rules. If the student is put in seclusionary timeout at 2:45 and the school day ends at 3:20, so same school day, you're required to notify the parents by 3:20, by the end of that school day, even though that's less than 1 hour from the time of the seclusion. And parents in school can agree to more frequent notification than what's required by the rules, but you can't agree to anything less than what's required by the rules. And that is just the initial notification. That doesn't mean the documentation. This is just a phone call or some other means of notifying the parent that this incident has occurred. Think of it as kind of an informal first notification. Then there's going to be a written form documentation that has to go out after the incident. Where is seclusion allowed to occur? Seclusion is only allowed to occur in a designated seclusion room, so designated by the building or the district that complies with the physical room requirements in Chapter 103. And I'll go through what those requirements are a little bit later, although that's probably more for administrators on here in designating those rooms. But I think it's important for everybody to be aware, because if you use a non-designated room, there is an exception, we'll get to that in just a second, that allows you to use a non-designated room. The non-designated room still needs to be safe and appropriate for the purposes, so it should still comply with the room requirements. So it has to be a designated room unless the nature of the occurrence makes the use of a designated room impossible, clearly impractical, or clearly contrary to the safety of students, others, or both. So, for example, a student engages in behavior and seclusion is the least restrictive option that is available to school staff, but you're in a building that doesn't have a designated seclusion room. So it's impossible to use a designated seclusion room because you don't have one in the building. So you have to use some other space. Or if you're in a very large building and the seclusion room is too far away from where the student is at the time, and there's no safe way to transport the student or to escort the student from where they are to the seclusion room. So under those limited circumstances, you may be able to use a non-designated space, but it should still be safe and it should still be a space that's appropriate for this purpose. No janitor's closets or rooms that have hazardous, objects or items in them. When a student is in physical seclusion, the employee has to maintain constant visual monitoring of the student for the entirety of the restraint or seclusion. You have to have eyes on them at all times. There cannot be any point during that restraint or seclusion where at least one employee doesn't have eyes on the kid. Because that is how students can get hurt. That can be really serious and really severe risk. And so you always have to have eyes on the student. An employee cannot use any physical restraint that obstructs the airways of the student. So prone restraints are prohibited. Prone is where a student is down on their stomach, and you're restraining them on their stomach. That's absolutely prohibited. Mechanical restraints are generally prohibited as well. There are limited exceptions allowing trained employees to use devices or methods that have been designed for that use and are incorporated into a student's IEP or health plan or safety plan. But again, if you're using a device, that has been prescribed to a student, or that you need to have been trained, not somebody else. You need to be trained if you're using that. And students who use sign language or any other augmentative mode of communication have to have their hands free unless it is not feasible in view of the threat posed. And so, if you're limiting a student's use of hands when they use them for communication, the threat needs to be pretty severe, and there needs to be no other way to protect against that threat. There are fairly extensive documentation requirements when physical restraint or seclusion are used. Of course, you have to include the name of the student, the name, job title of all employees who were present for this, if they observed, implemented, or were otherwise involved in the use of restraint or seclusion. All of those employees' names and job titles must be listed on the seclusion or restraint documentation form. You have to include the name of the administrator who approved restraint or seclusion beyond 15 minutes or any 30 minutes thereafter, if any. The dates that all of those involved completed their last Chapter 103 training. So, maintaining documentation of Chapter 103 training, like this one, is important for being able to comply with the documentation requirements under the Chapter 103 rules. The date of the restraint or seclusion, the beginning and ending times of the incident, description of the student's actions before, during, and after the incident, a description of the employee's actions before, during, and after the incident. Any approval for restraint or seclusion exceeding 15 minutes and a rationale for the time extension. So you have to explain on the form why the student still required physical restraint or seclusion beyond 15 minutes. And it has to be consistent with that requirement that the physical restraint or seclusion is only being used as long as necessary to resolve the threat or behavior that justify the use of physical restraint or seclusion in the first place. You have to include a description of the less restrictive means attempted to avoid restraint or seclusion, or if there was such an imminent risk of safety that there was no ability to use less restrictive means, you document that. If a student has a weapon, there's no other way to prevent harm, then you document the fact that you could not have done anything else under the circumstances. A description of any injury to the students or others or any property damage, a description of the future approaches to students' behavior, including any consequences or disciplinary action, and then the time and manner by which the parents were notified. And this is for that initial notification that has to happen within an hour or by the end of the school day, whichever happens first. You have to document the reasons for non-compliance with the rules, if applicable. So if for any reason the restraint or seclusion did not follow the rules of Chapter 103, you have to document why. You have to document if you did not obtain administrator approval at 15 minutes or every 30 minutes thereafter. You have to document if the parent notification rules were not followed and why that did not happen. And that may be, under rare circumstances where the threat went on for so long and there was no no ability to notify the parents within an hour. I wouldn't rely on that. I think that there's going to be an expectation that even if you can't stop and call the parents, that somebody does. But if there's some reason why, under those circumstances that day there was nobody available to call the parents, or you tried and weren't able to get through, you need to document that. Restraint or seclusion that lasted longer than necessary, why that happened. If a student is secluded in a non-designated room, and those are two examples that I gave earlier, either there is no designated room in your building, or it's too far away from the student, and transporting the student would not be safe in those circumstances, you document why a non-designated room was used. And then if a student was not provided with breaks for bodily needs after 15 minutes, why that was. And generally, that's only going to be because it would be unsafe to do so. It would be unsafe to allow a break. You have to provide this written documentation to parents, and it must be postmarked by the end of the third school day following the occurrence. So if an incident occurs on Monday, and you call the parents that day, but then you have to mail or otherwise provide this documentation to them by the end of the third school day, so Tuesday, Wednesday, Thursday, by the end of the day on Thursday at the very latest. Parents can agree to receive the notification by email or fax, but if they don't agree to receive it by email or fax, I don't know if anybody's using fax anymore, but it's still in there. Then the school has to put the report in the mail. You don't put it in the student's backpack and send it home. You don't give it to an older sibling. You put the report in the mail to the student, and we would recommend keeping a copy of that letter, as of course the form as well, and documenting when it was sent home, to ensure that if there's ever any question, you can show that yes, indeed, you did send it. You're also required to include, along with the notification of the incident, a letter inviting the parents to a debriefing meeting if that is required under the rules. And we'll talk about debriefing meetings in just a second. So if this is the first time that you're hearing those words, don't worry, we'll get there in just a second. And the letter that you send to the parents inviting them to this meeting has to include the date, time, and place of the debriefing meeting and the employees or individuals who will attend the meeting. So what is a debriefing meeting? A debriefing meeting is a meeting of relevant staff, family, and others to thoroughly discuss an incident of restraint or seclusion. The purpose of the debriefing meeting is to improve future outcomes by reducing the likelihood of future problem behaviors and future uses of physical restraint or seclusion. So, I said a little while ago that, the important thing here is to not be using physical restraint or seclusion where, in place of appropriate educational strategies and other interventions. And the debriefing meeting is part of how we get from here to there. Student is engaging in these behaviors. We need to find some way to reduce the likelihood that those behaviors are going to happen, not simply respond to the behaviors when they do happen. When are we required to have a debriefing meeting? Anytime the student is restrained or secluded for the first time in a school year, a debriefing meeting must take place. If a personal injury occurs of any kind, even if it's not the first time, a debriefing meeting must take place. If a reasonable educator determines that a debriefing session is necessary, a debriefing meeting must take place. So this is where, we need to be thinking, about when it might be reasonable to say, we need to call the team together and discuss this, even if it's not otherwise required by these rules specifically. Whenever a debriefing meeting is suggested by a student's IEP team, then it needs to take place, or any other time that a parent and the school officials agree to a debriefing meeting, it needs to be held. And then this last one is a catch-all. If none of these other ones applies, then we have to have a debriefing meeting after 7 instances of restraint or seclusion of that student in a school year. So we must have one after the first incident, and then after 7 incidents, if there hasn't been one in between for any of these other reasons, then by no means any later than 7. and then every 7 incidents after that. And we've gotten that question already. Does that mean after 7 we have to hold a debriefing meeting every time? Our understanding from the Department of Education is no, it would be every 7 instances after that time. So you have your debriefing meeting at 1, you have it at 7, you have it at 14. Hopefully you're not restraining or secluding more often than that, but if you are, count up by 7, and that's the minimum number of times that you can hold a debriefing meeting. You can always hold them more often if you need to. This is the list of people who are required to attend: parents or guardians of the students, and they're allowed to bring a representative if they choose to. The student, if it's appropriate for the student to be there, and if the parent gives consent for the student to be there. The employees or administrators who administer the physical restraint or seclusion. Any administrator or employee who is not involved in the incident, you have to have at least one who is not involved in the incident. If the administrator or designee approved continuation of the restraint or seclusion beyond 15 minutes, that administrator or designee has to be at the meeting. And then any other relevant personnel designated by the school. And if indicated under the circumstances, an expert in behavioral or mental health, and that can be somebody from the school or AEA who would constitute a behavioral or mental health expert. It doesn't have to be an outside, non-employee expert. What do the debriefing meetings cover? First, they cover, it's intended to be a collaborative discussion between the members of the team, which involves school staff, possibly AEA staff, parents, guardians, their representatives, and anybody else who's invited. Then you're required to examine and determine what caused the incident that led to the use of restraint or seclusion. The team can discuss or should discuss how restraint or seclusion could have been avoided if possible, and how future incidents can be avoided. So, what strategies can be used with a student to prevent that kind of behavior in the future? What strategies might school staff use to intervene to prevent the behavior from getting to that point once the student starts escalating? What is it that can be done to try to reduce the likelihood of future restraints and seclusions? The team should also plan for and implement positive and preventative supports to try to enable the student to comply with reasonable rules and not engage in the behavior that led to restraint or seclusion before we are even getting to the point of needing to intervene. There needs to be an agenda and a written report that is included in the that is documented as part of this meeting. The date and location of the meeting, the names and titles of participants, a copy of the actual 103 documentation from that incident. And if you're having one after several, you want to have, I think, all of the Chapter 103 forms up to that point available. A review of the student's BIP, individualized health plan, IEP, or safety plan, if applicable. And there needs to be a description or discussion of the identification of the patterns of behavior and proportionate response of the student and employees involved. Determination of possible alternative responses and any less restrictive means that could have been used, if any, under the circumstances. Identification of any additional resources that could facilitate alternative resources or responses in the future. And then any planning for follow-up actions. Do we need to conduct a functional behavior assessment? Does there need to be a revision to the student's intervention plan or IEP, BIP, and so forth? Is there a need for consultation with medical or healthcare providers? Do we need to develop a reintroduction plan to bring the student back into the school environment or to a less restrictive environment? Is there a need for an IEP meeting or an evaluation? Something that's important here is that this 103 debriefing meeting is not necessarily the same thing as an IEP meeting. And if you're going to hold an IEP meeting following or in tandem with a 103 meeting, you have to follow all of the requirements of IDEA, meaning that the parent has to be provided adequate written notice of the meeting. You have to have all required participants for an IEP meeting there or excused with input provided to the team as appropriate. You would need to document any changes in the IEP with a prior written notice. So make sure if the 103 debriefing meeting starts talking about changes to the IEP, if it's not as part of an IEP team meeting, those changes really can only be recommendations that are then taken to the student's IEP team to be included in the student's IEP. And if necessary, you might need to convene an IEP meeting as soon as possible to make those changes to the student's IEP. After the meeting, you're required to provide the parent with a copy of the written report within 3 days. And again, mail it unless they consent to receive by email or fax, but don't send it home with the student in a backpack. Don't send it home with an older sibling. Make sure that it's in the mail or emailed if the parent has agreed. If applicable, you need to follow the requirements of the IDEA and Iowa rules regarding IDEA or Section 504. If there is an agreement as part of the debriefing meeting that a student may be eligible for an IEP or a behavior intervention plan or a health plan or safety plan, so this is where a student may not already be eligible, doesn't have an IEP, a 504 plan, a safety plan, or so forth, but the team says, hey, we think that we might need to evaluate. You have to follow those requirements in order to determine whether they're eligible and then to develop the plan. And then any changes, like I just said a minute ago, any changes to an existing IEP, BIP, safety plan, health plan have to be made in accordance with the requirements of the IDEA or the requirements regarding health plans or safety plans. That may include the need to issue a prior written notice, following IEP team decision making, or to call together an IEP meeting if you didn't have that done as part of this debriefing meeting, which some teams will and other teams may not, choose to have the debriefing meeting and then an IEP meeting immediately following. Some of it depends on the timing, so you have to have this debriefing meeting pretty quickly. Physical requirements for seclusion rooms. So these are the designated spaces within schools that are designated for use for seclusion. But again, if you use a non-designated space because it's impossible not to, you need to still make sure that the space is safe and appropriate for that use. So physical requirements for seclusion rooms, they must comply with all applicable building, fire, safety, and health codes and standards, both the interior and the exterior of the room. The room space must be no less than 56 square feet. The distance between opposing walls has to be no less than 7 feet from one side to the other. Students have to be able to move about, recline safely and comfortably, considering the age, size, and physical and mental condition of the student who is being secluded. The room cannot be isolated from school employees or from the facility. The walls have to be freestanding and not, or I'm sorry, they have to be permanent, not freestanding or portable. And it must allow for the continuous visual and auditory monitoring of the students. You have to be able to see the student at all times, and you have to be able to hear the student at all times. And that is absolutely a requirement if you're going to be using a non-designated space. Simply, if it's impossible to do so or unsafe to get a student to a designated space, you have to be able, wherever you are, it has to be safe and appropriate for the use. And that includes visual and auditory monitoring the student throughout the entire incident of seclusion. There has to be adequate lighting, and light switches have to be outside of the room. There has to be adequate ventilation with any switches or controls to control the ventilation or fans, again, outside of the room. It has to maintain a temperature within the normal human comfort range that is consistent with the rest of the building. So it should not be significantly warmer or colder than the rest of the building. And the temperature controls have to be located outside of the room. It has to be clean and free from objects or fixtures that could be potentially dangerous to a student, including protruding, exposed, or sharp objects, exposed piping, electrical wiring, or other objects in the room that could be used by students to harm themselves or to climb up a wall. So this is sort of the catch-all. Look and examine the room very carefully and make sure there's nothing in there that a student could use to harm themselves or to climb on. And then there can be no freestanding furniture in the room. So those are the physical room requirements. Again, if you are an administrator designating space for seclusion, these must be followed. The only exception that is not immediately applicable is the square footage. You've got some time under the law that's grandfathered in, unless you make changes or start renovating your building, then you have to bring the square footage into compliance immediately. Otherwise, you have a few years under the law to bring those rooms into compliance, and should be working with your building and facilities crew to make sure that any spaces are are otherwise immediately compliant with all of the other requirements, save square footage. And currently, the rules prior to the January 20th rule still requires that it be reasonable size. So even if you are not required to comply with the square footage requirement today, you still need to make sure that it's a reasonable size in light of the student's age, physical and mental capabilities, and so forth. The room must be constructed for materials that are safe for their intended use, including any wall or floor coverings that may be used that are designed to prevent injury to the student. So they have to be safe for the intended use. The door has to open outwards. It may not have a lock unless the lock automatically releases when it's not being held in place by a staff member outside of the door. So pressure lock only that immediately releases when the staff member releases pressure. The door, when fully open, cannot reduce the required corridor width by more than 7 inches. And doors in any position cannot reduce the required width by more than 1/2. The room has to be able to be opened from the inside immediately upon the release of the pressure mechanism that is held in place by the employee. So the employee is holding the door closed. The minute that the employee releases that pressure, the student must be able to open the door from the inside. This is a matter of health and safety. It is not optional. And if there are any windows, the windows have to be transparent, see-through, and made of unbreakable or shatterproof glass or plastic as a safety matter for the student. Parent approval of the use of restraint and seclusion is not required. Chapter 103 requires that we notify the parents when physical restraint and seclusion are used, but there is no requirement that a parent provides consent, nor can a parent necessarily withhold consent from the school to use physical restraint or seclusion. And physical restraint or seclusion is an all-child rule, meaning that it applies equally to students with disabilities and students without disabilities. However, the use of physical restraint and seclusion for students with disabilities who have IEPs must be consistent with the student's right to receive a free and appropriate public education. So the IEP team must be involved in planning for that student's IEP and disability related needs to ensure that it's consistent with the use of FAPE for that student based on their individual student needs. The public agencies are required to comply with the requirements of Chapter 103, whether or not a parent consents to the use of restraint or seclusion. So, two things. First of all, if a parent says, put my kid in seclusion and leave them in there for 2 hours, you still have to comply with Chapter 103. Even if the parent's saying don't comply, you are, as a school employee, still charged with complying with these requirements. On the other hand, if a parent says you are not allowed to, ever place hands on my child, you still have the right under Chapter 103, consistent with your training and consistent with the circumstances, to use reasonable physical force, including physical restraint or seclusion, where necessary and reasonable, to accomplish one of the permissive purposes of Chapter 103, preventing imminent harm, preventing a serious disruption, preventing significant or serious damage to property of significant value. And a determination of when it's reasonable and necessary is always going to be made on a case-by-case basis based on the facts present under those circumstances. But consent and notification aren't the same things, and it's important to be aware of that. You as a school employee still have the right to protect yourself and the responsibility to protect other students where necessary and where less restrictive means aren't available or aren't effective. Just touching back on room clears for the last few minutes, and the new law requires that room clears only be used to prevent or terminate an imminent threat of bodily injury to a student or another person in the classroom, and room clears cannot be included in a student's IEP or BIP. Notification requirements. By the end of the school day or within 24 hours, the principal is required to notify the parents of all students in the classroom where the room clear occurred. And there's specific requirements of what that notice has to include, but it cannot identify the student involved in the incident. So we have to provide parent notification, but not identify the student. And then the principal is also required that the parent or to ask the parent or guardian of the student involved in the incident that led to the room clear to meet with the principal, classroom teacher, and other appropriate staff to have like a debriefing meeting following the room clear. And if a student has an IEP or a BIP, then an IEP meeting has to be called to discuss the incident leading to a room clear. Chapter 103 and the room clear law. I know it's a lot of new information and a lot of changes for those of you who have been sort of practicing in this area for a while. Chapter 103 prohibits restraint and seclusion unless less restrictive alternatives would not be effective, would not be feasible, or would have failed under the circumstances. And it's important to note now that a room clear may not be used as a less restrictive alternative to the use of restraint or seclusion. And it's also important to note that Chapter 103 allows the use of restraint or seclusion if a student is posing a serious disruption to the learning environment, but a room clear would not be allowed if there's a serious disruption, unless that serious disruption is an imminent threat of bodily injury. So if a student is screaming obscenities and verbal threats, but is not posing any threat of harm to themselves or others, you cannot use a room clear, but you may be justified under the circumstances potentially in using physical restraint or seclusion to deal with that serious disruption. Again, it's always going to be very fact specific in determining what is reasonable under the circumstances. I want to thank you all for your attention and participation in this training. If you have any questions about the contents of this training, please direct them to the appropriate administrator or administrators in your agency, and administrators who are permitted to contact legal counsel. Please feel free to reach out to legal counsel for your agency with any questions or follow-up regarding these changes to law. Again, thank you very much.